Hi, I'm Casey Havluciyan, and I'm here to give you some exciting information about motions to compel. Let's start by answering the question, what is a motion to compel? Well, a motion to compel asks the court to either order either the opposing party or a third party to take some sort of action. This sort of motion most commonly deals with discovery disputes. When a party who has propounded discovery to enter the opposing party or a third party believes that the discovery responses are insufficient. The motion to compel is used to ask the court to order the non-complying party to produce the documents or information requested and or to add sanctions to non-complying party for failure to comply with the discovery requests. So now that we understand why someone would want to compel a motion, now we can look at how you get to the point where you would need to compel or get somebody to do what they're supposed to do. A motion to compel asks the courts to enforce a request for information in a relevant case. Here are some general sequences of events that filing the motion to compel. First, the lawsuit officially begins when the plaintiff initiates a civil action against the defendant. We learned this early on in the beginning chapters of our book. Discovery requests have parties request for evidence such as documents and other relevant information from the opposition. Each party is required to respond to the request by a specific deadline. If one of the parties does not cooperate, refusing to answer questions for discovery or fails to respond to the deadline, then the lawyers would have to meet and confer. This is an informal attempt to make or resolve the disputes about the discovery requests. Finally, if nothing can get finalized in the meet and confer, they would move for the requesting party to file a motion to compel discovery responses. If the opposing party continues to deny the discovery request. When a motion to compel is filed with the court, a hearing will be scheduled. At the hearing, the party that filled out the motion will need to tell the judge why the other party should be compelled to do something. Once that happens, the party will not be able to use the documents in the trial. So let's look at the specific motions to compel. First, there are interrogatory responses. Interrogatory responses we learned in a previous chapter as well. It's a prime example of a motion that gets frequently filed in courts. This is when you've received a response to interrogatories or questions that you believe are incomplete and you want the court to order the responding party to provide further responses. Second, you have motions to compel testimonies or depositions. A party may move for an order to compel the deposition attendance at a testimony and production or inspection of any document. Which brings us to our next, a motion to compel a document. Demanding a party to move to compel compliance if the responding party fails to permit the inspection, copying, testing, or sampling in accordance with the party's statement. And lastly, we have a motion to compel answers or admissions. The propounding party gets the answers they want, keeps the peace during litigation and prevents discovery process from escalating to an all-out war. So let's take a closer look at interrogatory responses. Some grounds for a motion to compel interrogatory responses would be if the responses were given but they were incomplete, evasive, or without merit, meaning they were too general. Then the following requirements would be the next would be the requirements to be fulfilled for the motion to compel interrogatories. First, you have to identify the name of the person in question and the set number in question. You would meet and confer with opposing counsel, and then you would create a separate statement. The deadline to file would be 45 days. It must be filled within 45 days from the insufficient response. Motions to compel deposition testimony. Grounds for the motion would be a party to move to compel answers to a deposition question or the production of documents if the deposition is either does not answer the question or does not bring the document requested, as in the subpoena. The requirements for the motion are a meet and confer and then creating separate statements. An adjourning deposition can be made if it does not answer the questions. May choose to adjourn the deposition to file the motion or complete the deposition on another manner. Unless the answer is necessary to move forward, the latter usually is more practical. And there's also a notice of a motion may be given to do an oral deposition. And that would be for a party witness. Deposing attorney may give notice of the time and place of the motion. This all has to be done in 60 days is the timeline. Motion to compel must be filed within 60 days from the completion of the deposition transcript. Motions to compel production of documents. Grounds for the motion. The party must move to compel production of documents or things if the respondent agrees to comply but the compliance is incomplete. The responding party indication of inability to comply is incomplete, inadequate, or evasive. Or 3, the objection to the request that is made is too general or without merit. The requirements for the motion would be to identify the interrogatories or the question by name and set number. You would meet and confer, and then you would do your separate statements, and then you would attach the deposition transcript before filing. The deadline to do so would be 45 days from the insufficient response. Motions to compel or request admissions. Grounds for a motion. A party may move to compel or additional responses to a request for admission would be if 1, a response was evasive or incomplete, or 2, the objection that was made was too general or without merit. The requirements for the motion would be to identify the interrogatories and this by set name and number, would meet and confer, and then the separate statements are required. The deadline to do so would be within the 45 days. So this is just a review of the pre-motion timing. For written discovery, it is 45 days. Motions to compel may be filed 45 days after the insufficient response. 60 days for depositions. Motions to compel depositions to answer may be filed within 60 days of the completion of the deposition's transcript. No time limit for no responses or unverified responses. If an unverified response or no response is at all, there is no time limit to move to compel. You can do so at any time. You also have to add time if the responding party served was insufficient. You have to add time by mail. 5 days if mailed in California, 10 days mailed in the U.S. outside of California, and 20 days if mailed outside the United States. The final deadline is 15 days before a trial date. The final day to hear discovery motions, including motions to compel, is 15 days before the initial discovery deadline. Practically, this means the motion must be filed well in advance. So what does it mean to meet and confer? Moving party must include a declaration stating the facts that show a reasonable and good faith attempt at an informal resolution of each issue presented by the motion. If they have to take it further, they will file sanctions for failing to meet and confer. The court shall sanction the moving party if he files a motion to compel before attempting a reasonable good faith attempt to meet and confer with the responding party. Note, there is no meet and confer duty when no response is served. So let's look further at our case that we've been working on since the beginning of class, and that's the Sampson versus Emerald Catering. Let's say in this scenario, Emerald Catering has failed to provide fully the information on why they did not answer the phone the night of the event. So Sampson is making a motion to compel deposition questions and motion to compel the phone records. This would be if Sampson had already requested and they attempted to get the information first, then they met and conferred with the lawyers and nothing still happened, then their last resort is now to create a motion to compel. And they would create this document, and they would have to include all of these elements in order to satisfy the document. So first, the parties must be identified. So you can see that Benjamin and Sarah Sampson are the plaintiff, and Emerald Catering, this is the name addressed to the parties, and then briefly stating a motion for the relief sought. So this is a notice of motion and a motion to compel testimony at the deposition and the production of the documents, meaning the phone records. And they're saying if they do not do so, then they will fine them $5,000. If the pleading is challenged, the state portion is challenged, then this must be included as well. So here's a little bit of an overview of how you would file the motion. You would send the notice of the motion, which would be the written notice that the motion has been filed with the court, and the date in which the hearing will be held. The motion itself, a petition satisfying what is being asked for by the court, and then we go into points of authority, which my friend Ryan will be discussing with you shortly. And that is the end of my presentation. I hope you learned a lot about what it means to compel. Thank you.